Welcome to the ABF Journal Podcast. I'm your host, Rita Garwood, and today we are diving into the complex, high-stakes world of liability management exercises. From the Serta Simmons case to the latest maneuvers from companies like SonicWall and Medical Solutions, today we're going to explore how shifting legal precedents are changing the rules for lenders and borrowers alike. Before we get into it, I would like each of you to just introduce yourselves briefly. Julian, you want to
Sure.
go?
Thanks, Rita. I'll go ahead and start. Hi, I'm Julian Bulaon. I am the head of liability management for America's Covenants at Octus, where I eat, sleep, and breathe liability management exercises every hour of my day. The main focus for my day-to-day is reviewing credit agreements and bond documents for the kinds of loopholes that allow these transactions to take place.
Melissa?
My name is Melissa Kelley. I am the deputy head of the America's Covenants team. I do a mix of both primary market analysis as well as liability management analysis with Julian. And prior to coming to Octus, I spent about 9 years litigating LMEs on both in New York and actually in London.
Great. So, Julian, we'll start with you. For those who have not lived and breathed this for the last few years, can you just take us back to 2020? What exactly did Serta Simmons betting do with a handpicked group of lenders that sparked this multi-year legal war?
Thanks, Rita. So in 2020, Serta Simmons did what we now call a non-pro rata contractual up-tier. So back in 2020, lenders holding a bare majority, around 51% of Serta's outstanding first lien term loans, exchanged their loans into new super priority debt that was secured by super senior liens on the collateral. The new super priority facility included a first out new money tranche, and then the exchange debt sat in the second out tranche. Now, the participating lenders did this by amending the credit documents in a way that subordinated the existing term loans liens to the new super priority debt. And on top of that, the majority amendment also stripped out restrictive covenants and various other lender protections in the debt that was left behind. The result was that the excluded minority lenders, that 49% group, were left behind holding lien-subordinated and covenant-stripped paper. Now, the Serta transaction was a real shock to most credit market participants back in 2020. At the time, non-pro rata up-tiers like this were generally seen mostly as a feature of the high-yield bond market, but not of the first lien term loan market. You just weren't supposed to be able to do this sort of thing to first lien term loans because they're generally understood, in theory, to be the safer instrument. While the BSL market had, in fact, seen an earlier version of something like an up-tier back in 2017 in a transaction done by a company called NYDJ, or Not Your Daughter's Jeans, the loophole that allowed that older vintage transaction was widely thought to have been addressed by the market, and in fact had been closed in Serta's credit agreement. So that was one of the reasons it was so shocking, because it got around the NYDJ type loophole. Before I hand things over to Melissa, I think a really helpful way to understand Serta or think about Serta, and Melissa will talk about this a little bit more, is that it really breaks down into two analytically distinct steps. First, there's the non-pro rata piece of the transaction. That's the unequal treatment of the 51% vis-a-vis the 49%. The second component is the contractual subordination piece. That's where the minority lenders were subordinated without their consent. Now, both steps were intensely litigated over the course of the years that followed, but it's the non-pro rata piece that's especially important because that was the focus of the Fifth Circuit's decision in 2024, and it's also the focus of the decision that's currently pending before the bank.
So, Melissa, most credit agreements have sacred rights that require all lenders to be treated equally. How did Serta and its majority lenders use the phrase open market purchase as a loophole to bypass those protections?
Thanks, Rita. So kind of to build on both what Julian said, but then to provide a bit of context, credit agreements usually contain a clause that's called a pro rata sharing provision. It's a fundamental contractual mechanism in credit agreements, and it requires a lender to share any payments received in excess of its proportional or pro rata share of the loan facility with all other lenders in the same class. And the purpose of that is to ensure that each lender receives payment according to each lender's ownership percentage in the loan. That expectation of pro rata treatment mirrors bankruptcy principle of equal treatment of similarly situated creditors. For that reason, it's very important, and it's often protected as a sacred right. But pro rata sharing provisions also often have exceptions. And those exceptions are what borrowers and majority lenders rely on to effectuate consensual liability management exercises. And the presence of those exceptions, or if your ability to amend the pro rata sharing provision to provide for exceptions, are critical risks in credit agreements, and they're what we look for on a day-to-day basis when assessing the possibility of a liability management transaction. So Serta's agreement contained a pro rata sharing provision, and it protected that provision as a sacred right. But the pro rata sharing provision expressly did not apply to payments for assignments through open market purchases. I think that's a phrase now that everyone in this area is familiar with. And Serta and its majority lenders said that the non-pro rata exchange into the super priority loan was an open market purchase, and so it wasn't captured by the pro rata sharing provision. Now, as Julian mentioned, of course, the credit agreement also lacked a sacred right against lien subordination, and that has now given rise to the eponymous blocker that we know as a Serta blocker. So the lack of the sacred right against lien subordination permitted the priming debt with majority consent. The open market purchase exception permitted a non-pro rata exchange into that priming debt.
So we recently saw the Fifth Circuit reverse the bankruptcy court's ruling. What was their specific problem with how Serta defined an open market, and why did they call this a violation of the credit agreement?
So the phrase open market purchase was not defined in Serta's credit agreement. And Serta and majority lenders argued that it meant to acquire something for value in competition among private parties. The Fifth Circuit held that it meant a purchase of corporate debt that occurs on the secondary market for syndicated loans, very different from what Serta was arguing. There's a few reasons for the Fifth Circuit's interpretation. Two of the main ones were first, kind of looking at ordinary dictionary and legal definitions, particularly from New York State courts and authorities. And based on those sources, the Fifth Circuit determined that Serta's proposed definition just didn't use the word market. It forgot the word market, I believe, was its precise wording. And the Fifth Circuit felt that an open market purchase has to be a designated market, not background concept of free competition. And here, the designated market would be the secondary market for syndicated loans. The Fifth Circuit also kind of got there based on the structure of the relevant provision in Serta's credit agreement. That provision provided for two exceptions to pro rata sharing, through a Dutch auction or by making open market purchases. A Dutch auction kind of is what it sounds like. It's an auction. And the Fifth Circuit said the two shouldn't be the same things. This is kind of a principle of contractual interpretation that all words need to be given some sort of meaning. So if you had adopted Serta's interpretation of open market purchase as something for value and competition with private parties, it also would mean that the Dutch auction was the same as an open market purchase. And the Fifth Circuit said that each need to have distinct meanings.
So we're seeing a surge in LMEs across companies. Medical Solutions and Sonic Wall are examples. Julian, is this a sign of a last gasp for these tactics before the Serta precedent takes hold, if it ends up taking hold, or is the market simply finding new ways to evolve the playbook?
Sure, it's a good question. First, I'll talk about the surge in liability management exercises, which, in my mind, the surge really happened or kicked off in 2024. That's when we saw sort of the record year of transaction volume. In 2025 was a close repeat of that volume. What was different about the post-Serta decision era is how people got to the non-pro rata outcome. So to answer the specific question here, and let me first talk a little bit about what we mean by the Serta precedent, which I assume you mean the Fifth Circuit decision. The effects of that ruling have already taken hold. We are very much firmly in the post-Fifth Circuit era, which means the open market purchase exception that Melissa described is no longer really the favored or considered really a feasible route to a non-pro rata transaction. But non-pro rata transactions are still very much on the table. It's just that companies and the majority lender groups that they work with have to rely on different exceptions or loopholes to get there. I'll give you some examples. So even now in this post-Serta era, top tier sponsors are frequently and successfully negotiating for privately negotiated purchase exceptions to the pro rata sharing provision. So instead of having an exception that says that you can make open market purchases of term loans on a non-pro rata basis, there's language now that's being inserted that says, or on a privately negotiated basis. And really the purpose of that language is to sidestep the Fifth Circuit's ruling to say the contract clearly permits something other than an open market purchase. There's also these creative structures that the market's come to call extended exchange that were pioneered by Better Health and Oregon Tool literally weeks after the Fifth Circuit's decision, which was very clearly an end run around that decision. It's less common these days. We still see it from time to time, but it's always lurking in the background as a potential threat as it takes advantage of another very common exception to pro rata sharing provisions. And of course, it's still possible that pro rata sharing itself just isn't a sacred right, which is what we call the NYDJ loophole. That's less common these days, but we still see it from time to time, especially in older vintage deals that originally closed maybe back in 2019 and have been amended or refinanced multiple times, carrying over the same loopholes for several years. So to answer your question directly, it's not the last gasp. It's evolution, not extinction.
So Melissa, from a covenant perspective, what makes the concurrent situations at Medical Solutions, SonicWall, and Stars different from the standard LMEs that we've seen over the last few years?
So Medical Solutions and SonicWall are both private companies, so we can't discuss the documents in depth. From what we know from publicly reported sources, SonicWall is heading towards a pro rata LME. We don't know if that's because of document restrictions or other factors, but we have generally seen the market move towards more inclusive LMEs. I think some of us at Octus, Julian included, refer to them as kinder, gentler LMEs. And I've heard some market participants just say that transactions are getting more boring because they're becoming pro rata. On the other hand, Medical Solutions is reported to be a non-pro rata LME with a 20 to 30 point delta in debt exchange economics between the SteerCo and non-SteerCo co-op lenders. I think what makes Medical Solutions interesting, my understanding is that there is a co-op that is open to all, but it sets up 4 potential tiers of treatment for lenders in an LME. Certain of the lenders that certainly that we've heard reported, were a little bit disconcerted by that. Now, tiered economics aren't new whatsoever in co-op agreements. But here, because you're entering into the co-op agreement without knowing what the economics ultimately would be, there was a concern that lenders had a concern that they wouldn't know what their eventual recoveries would be. There's also a holdout group that is co-opt, and I believe they are represented by Cadwalader. But I think what we can assume from a covenant perspective is that if they're going down the non-pro rata LME route, there's kind of an exception or a structure under the documents that will allow a non-pro rata exchange. We just don't know what it is. Stars is, I guess, in a slightly different bucket. It also concerned a non-pro rata up-tiering, specifically a bond swap, but it's presently the subject of litigation. And there were all sorts of claims brought against the company. And recently there was a motion to dismiss decision, and the breach of contract claim that survived was for a breach of a sacred right, and that particular sacred right prevented modifying the notes guarantee in a matter that was adverse to the holders, or releasing the guarantors that constituted all or substantially all of the value of the notes guarantee. And this brings up 2 issues that we've seen before in litigation concerning non-pro rata LMEs. The first is whether excluded note holders needed to allege that the transaction amendments themselves modified the specific sacred right text, or whether they could allege that it modified other provisions of the indenture relevant to the sacred right. And here the court said it was the latter, sufficient to allege that the transaction amendments modified the text of the provisions of the indenture relevant to that sacred right. The second is the meaning of all or substantially all. It's a real thorny legal issue, and with no real clear answer, and an argument implicating the meaning of all or substantially all also was made in STG. So I think Lionsgate presents a lot of the same legal issues that we have seen with respect to non-pro rata LMEs that have been challenged in court.
So Julian, Octus is tracking all of these concurrent LME situations. You've mentioned that the market is already repricing lender risk ahead of the Serta ruling. How are you seeing the market reacting to these transactions in terms of the evolution and adoption of lender protective deal terms?
Sure. So this is one of my favorite parts about doing liability management work. Here's how the market generally reacts. When a particularly alarming or shocking LME happens, the market's going to respond by crafting new contractual protections, or what we call blockers, that are designed to shield lenders from the risk of that specific kind of transaction happening to them in the future. The fun part about this is that these blockers end up being named after the company that did the transaction in the first place. So a Serta blocker, for instance, is a sacred right that requires individual lender consent to contractually subordinate lenders' lien or payment priority to other debt. If a Serta blocker had been in place in Serta's credit agreement, the transaction never would have happened. In the years following the Serta 2020 up tier, we did see a steady increase in the prevalence of Serta blockers in broadly syndicated loan documents. Back in 2020, I think it may have been present in less than, say, 50% of BSL issuances. Today, it's a far greater percentage than that. So I mentioned the Serta blocker specifically, but there's plenty of other transactions that have given rise to blockers. We've been naming blockers for at least 10 years now, going back all the way to 2016, starting with J.Crew, which was the notorious material IP dropdown, all the way through to just this last February, where Xerox did a similar dropdown, but in a way that still managed to push boundaries 10 years after the fact, or 10 years after J.Crew, which it's still so surprising to me that it continues to surprise people that there are these types of workarounds. But that's the nature of this practice or this discipline, let's call it. So some blockers are quite prevalent today in the BSL documentation, namely the so-called big three blockers. I already mentioned Serta. J.Crew and so-called Chewy blockers are also very prevalent in the broader BSL market. But there's almost a dozen other named blockers that haven't really received the same uptake, at least in the regular way, primary broadly syndicated market. Blockers like Envision, At Home, Wesco and Clora, Pluralsight, Xerox. But those next generation or more exotic blockers, let's say, are increasingly becoming the norm in post-LME or post-restructuring documents. Post-LME documents being the super priority credit agreement. Because you can bet the lenders that just did an LME transaction are going to plug every single loophole that they themselves took advantage of to get the deal done in the first place. So there's a differential here between which blockers have been adopted and which have not. I think what's really driving that is negotiating power among borrowers on the one hand and their creditors on the other, supply and demand, really. These protections are just generally known to the market. People know what Envision blockers are. People know what anti-LME blockers are. They know them really well, especially if they read Octus. So this isn't a function of people not knowing how to include these blockers. They just aren't in a position to win them in a negotiation because there's too much money chasing too little supply.
So we're seeing a split between pro rata and non-pro rata maneuvers. Melissa, does the pro rata approach offer a safer legal harbor for sponsors, or are we entering an era where any priority shifting move is going to be litigated regardless of how it's structured?
So I don't know that I would say that it offers a safer legal harbor. I do think litigation risk is increased with a non-pro rata LME. And most of the litigation that you've seen, starting with J.Crew through to today, we're just talking about, for instance, Lionsgate concerned non-pro rata transactions. I will put an asterisk next to that because there's one particular one that we have seen out of, it's a European LME, but concerned New York law governed debt documents for a company called Selecta, a Swiss vending machine company. And they carried out a pro rata LME, but the debt into which the initial debt was exchanged came with terms that allowed lenders to go from what was third out debt to first out debt. But in doing so, the first out debt didn't have the usual sacred rights that you would expect. I actually don't think it had any sacred rights. Everything could be modified by a bare majority. So that meant, and because there was an ad hoc group that held a majority of that debt already, it meant that excluded lenders from the ad hoc group were pretty much guaranteed to subsequently be put through a non-pro rata LME. That transaction, the first transaction, which was the pro rata step, is actually the subject of some very interesting litigation right now. So never say never. Some pro rata structures can certainly give rise to litigation, but I do think your litigation risk is going to be increased with a non-pro rata LME.
So if the bankruptcy court ultimately aligns with the Fifth Circuit's skeptical view of open market definitions in Serta, how significantly does that narrow the path for future priority shifting transactions? And could this effectively restore the sacred status of pro rata sharing covenants across the broader market?
So I think as Julian said earlier, certainly as far as the Fifth Circuit goes, and I think the entire market's view is the meaning of open market purchase is settled, and there is, it's not a viable path any further to effectuating a non-pro rata exchange. But given the Fifth Circuit decision, the participating lenders in Serta have pivoted to the argument that the pro rata sharing provision doesn't apply to the up tier in the first place. That argument matters because if the pro rata sharing provision applies, minority lenders can recover from participating lenders on the basis of the pro rata sharing covenant. Now, allegedly, I say allegedly, the argument that's being put forth by the majority lenders is that the pro rata sharing provision only applies to cash payments, and the super priority debt exchange was not a cash payment. And the majority contends that the covenant is very well understood in the industry, that it should only be addressing situations where there was a computer error or some sort of accidental inadvertent overpayment to certain lenders. And we've seen this argument made with increasing frequency before courts, especially in connection with priming dip roll-ups. It was made in American Tire, it's been made in Del Monte recently, and even before American Tire, we saw it in JCPenney. Disputes were settled in JCPenney and American Tire. We're still waiting to hear on Del Monte. So it is something that could have ramifications across the industry in terms of how the pro rata sharing provision applies. But I think the way it's applied in these circumstances, its utilization is a bit, when I say these circumstances, I mean the Serta bankruptcy case. I think it's a bit distinguished, and I'm going to pass it to Julian to say a bit more here.
No, that's great context, Melissa. Yeah, like I said, we are firmly in the post Fifth Circuit era. The Fifth Circuit's interpretation of open market purchase isn't going away anytime soon. But the end of the Serta saga, really, we really haven't reached it until we get the bankruptcy court decision after the remand from the Fifth Circuit. And the question that's in front of the bankruptcy court now is, does this pro rata sharing provision in fact apply in the first place? I think that's it's not a crazy argument per se. It's actually, Melissa said, it's already been argued in multiple other contexts. It does strike me as lacking credibility in this particular case with this particular litigation history and record, because we've spent the last almost 6 years assuming that the pro rata sharing provision was going to be relevant and was going to apply to this situation, and spent just as many years talking about what an open market purchase is. None of that stuff matters if the pro rata sharing provision doesn't apply. So it's just extraordinary to kind of throw all that ink and brain damage, and down the drain to come up with a completely fresh argument about a foundational issue. But they have to make the argument. They have to play it forward. I expect that the bankruptcy judge will not do anything to upend the Fifth Circuit's interpretation or Fifth Circuit's posture. But if that argument prevails, it has serious consequences for the loan market, and which is why I think we're less likely to see it take that direction.
So are we seeing a shift in how lender groups are forming? Are they becoming more pact heavy to prevent being the excluded lender, or are they adopting a more isolationist approach? Any differences that you're seeing?
So I do think there is a shift in a couple of ways. The first is that groups are co-oping earlier. So, back when I started practicing, it was a group of distressed funds who would spot an opportunity. You call your agent or trustee to interview firms, and you have a beauty parade of law firms. Now, as soon as debt drops below par, law firms are knocking at the doors of CLOs. So the law firms are really the catalysts for co-oping. And the law firms that are active in this space, both on the lender and borrower side, are really well-oiled machines with practices dedicated to finding these sorts of opportunities. And I think the rationale here is to have in place a group that gets you to consensual LMEs, although everything has an exception. And I think the two exceptions here would be sometimes you end up with a huge holder who is very aggressive and experienced these transactions, who is kind of happy to go at it alone. And then, sometimes you'll have minority lenders or holdouts who are willing to gamble on a par payment at maturity, or to dig their heels in and litigate. In that scenario, you're probably going to see minority lenders forming a group of their own. The second is that I've heard from a few market contacts that co-ops are now including explicit carve-outs that the obligations under the agreements don't extend to the provision of new money that's completely unrelated to existing debt. And that's to address the Optimum lawsuit that has been filed against the co-op group there. To the extent that can be said to portend any risk, I don't think most of the market thinks that it does, but that's the way that it's being dealt with.
So for the asset-based lenders and specialty finance professionals in our audience, they often feel like they have a better hand on the collateral than a cash flow lender might. Are these LME tactics starting to bleed into the ABL space, or is the asset-heavy nature of our market a natural deterrent?
Fortunately for these types of lenders, in my view, these tactics haven't bled into that space. I say fortunately because asset-backed finance has bigger problems to deal with in the wake of first brands. But I'll say a little bit more about why I think these types of lenders aren't as vulnerable. Revolver and cash flow lenders or ABS lenders of that type, I think are usually viewed as civilians or non-combatants in an LME scenario. Unlike funded term debt, that's an ongoing relationship that you're relying on for your day-to-day liquidity needs. And in most of the LMEs we see, the revolver or any asset-backed facility is either taken out at par or rolled into the new LME structure on the most favorable terms. They're usually not the ones, I can't recall any recent examples where a revolving or other cash flow type lender was forced to take a haircut or was forced to eat terms that they otherwise didn't really consent to. Well, that said, well-advised revolving or other cash flow lenders aren't resting on this custom, and I think that's pretty wise in this market. They're increasingly negotiating for tighter protections when the opportunity arises. So last year, for instance, Hertz's revolving lenders agreed to a maturity extension amendment, but only on the condition that that amendment also include the full suite of LME blockers that I sort of hinted at in a few questions ago. It effectively ensures that if Hertz decides to pursue an LME, it will need to be done on terms acceptable to the revolver. So again, not relying on custom, not relying on the relationship, relying on hard contractual language, which is a very wise thing to do in this market because relying on the relationship too much can get you into trouble.
So last question I have for you. If 2020 through 2024 was the era of lender violence, what do you think we will call the next 2 years? Are we moving toward a more collaborative restructuring environment or just a more litigious one?
Yeah, well, first, I appreciate you putting a perimeter around the 2020-2024 window. It really was its own era. You can consider the modern LME era starting in 2016, with J. Crew, but really 2020 to 2024 is, in my view, the really striking period, which was kind of the Wild West before the Fifth Circuit stepped in and attempted to impose some order on this area of the market. I don't think that 2024, though, marked the end of the lender-on-lender violence era. Serta was not the only decision that dropped on New Year's Eve 2024. There was also Mattel out of New York, which upheld a non-pro rata up tier just on different facts and contractual language. When you read those two decisions together, it's clear then that the permissibility of these transactions really comes down to what the contract says. So it doesn't mean pro rata, non-pro rata is going away. It just means that people are going to have to read the documents a little more closely. So we're still in an era of violence. It's just a little softer, I would say, and also a bit more normalized. People are a bit more used to these risks. They're aware of them, and they have processes in place to spot them. If I was forced to call this era something else, something catchy, I think you could say that we might be entering an era of stochastic lender violence, where there's, marked mostly by a steady flow of regular LMEs that are still, forcing haircuts. People don't love them, but we're used to them and they're not entirely unexpected. But those regular deals are going to be punctuated with moments, I think, of extreme aggression and innovation, especially as we approach this, dreaded great 2028 maturity roll. Xerox was a recent example of a drop-down financing, like I said earlier, that still managed to push boundaries almost 10 years after J. Crew, when people thought they had locked down the drop-down problem. Surprise, surprise, we're still getting innovation in 2026, and I expect we'll see plenty more of it in the years to come.
Well, thank you both for being on the podcast and talking through this entire topic. I really appreciate you taking the time.
Of course, it was a pleasure being here.
Thank you for having us.